Welcome to Illuminating Hope, a podcast of Hope House. In this series, Advocating Justice, the Legal Battle, we dive into the legal battles that shape the fight for domestic violence survivors. In each episode, we bring you powerful conversations with the legal teams, court advocates, and change makers working tirelessly to bring justice, protection, and hope to survivors of domestic violence. From the courthouse to policy changes, from survivors' rights to legal strategies, we uncover the critical role the justice system plays in breaking cycles of abuse. Whether you are a survivor, advocate, or someone passionate about justice, this podcast series will empower and inform you. Justice isn't just about the law, it's about giving survivors a voice, protection, and a future. Tricia M. Scaglia is a solo practitioner in Independence, Missouri, practicing primarily in the area of family law and juvenile law, frequently serving as a guardian ad litem and mediator. A lifelong Kansas City resident, she received her Juris Doctor from the University of Missouri, Kansas City, where she serves as a professor. Ms. Scaglia received a Bachelor's of Journalism and a Bachelor's of Arts from the University of Missouri, Columbia. She served as a law clerk to the late Honorable Kelly J. Morehouse, 16th Judicial Circuit of Missouri, and to the Honorable Robert E. Larson, United States District Court, Western District of Missouri. Ms. Scaglia serves on the Links Literacy Kansas City Board of Directors and the Missouri Bar of Governors. A frequent CLE contributor, she has provided the annual Family Law Update for UMKC since 2005 and has presented on the Missouri Legislative Update for the last several years. Ms. Scaglia is licensed in Missouri and Kansas. Hi, Tricia. Welcome to the Illuminating Hope podcast. We're glad you're here.
Well, thank you for having me. I'm honored to be here.
Can you explain to me what a guardian ad litem does and how do you advocate for children in legal cases?
Being a guardian ad litem is you need to be a lawyer, and it's truly the best and worst of what I do. And by that, what I mean is that you have children that they receive a lawyer to advocate for their best interest if there's a case of abuse or neglect, or if the court finds that it's in their best interest to have someone to advocate for them in their best interest. High conflict families, obviously many times that's families that have been involved in domestic violence, or either typically mother's the victim, or the children have been victims of either physical or sexual abuse.
And being a guardian ad litem is just part of what you do for your vocation. Can you talk a little bit about what else you do?
As a licensed lawyer, I certainly represent all sorts of folks. I represent children when I'm appointed as guardian ad litem, but I also represent moms and dads and grandparents and aunties and uncles. Primarily my area that I practice in is in family law and in juvenile law. Of course, those folks often have other issues that they encounter, particularly in dissolution cases, whether it be a small claim, a landlord-tenant issue, maybe a collection issue, be a traffic matter, could be a DUI matter, and that's all part of what I do and represent people here in the community.
Before we started, I brought up a presentation that you did back in 2010, and I told you I was quite a presentation geek myself, so I would love to hear about it, and I'll just kind of set it up for you. The Association of Women Lawyers of Greater Kansas City you presented to. The name of the presentation was How to Handle a Dissolution for Victims of Domestic Violence. Can you share that a little bit?
Sure. I think it's always unique when you represent a victim. There are different challenges that victims have, both to resources, information, and just a willingness to come forward. The theme is just meeting folks where they're at, understanding that victims may not always be forthcoming. And when I presented that to the women lawyers, that was one of the items really to make sure that they understood. And also that there are available resources in the community, obviously like Hope House, what you can do to link up victims. Also, it is a statutory factor that the courts can look at in terms of both in custody cases if there has been a pattern of domestic violence. That's important for people to know, victims to know, and lawyers to know. And also that if there has been any type of misuse, abuse of resources financially during the marriage, during the proceedings, that's something courts can look at in terms of property division as well. I think it's just so important for victims. Really, they're focused on typically custody, because in my practice, typically when I represent a victim, they also have children involved. It could be very small children, it could be children that are nearing the age of emancipation, but that's their focus and their priority is making sure that the children are safe and cared for, and then oftentimes with victims putting their needs not just secondarily but much further down the list, and just reminding them that they've got to advocate for themselves and they have to let you, the lawyer, know what's going on with them.
When you're working with other lawyers, what's the general understanding of domestic violence? Do you feel like it's better, that people are understanding domestic violence better, or is there still a lot of work to do with attorneys on understanding the issue?
Over the course of my career, I think it's certainly gotten better, and in large part due to you all and your work, just being out there in the community. People know, certainly on the order protection docket, Hope House and your advocates are a mainstay. Everyone knows that there's a lot of work that needs to be done still, and we never can lose sight of that. Certainly the partnership with KCMBA, CLE that's put on every fall, that certainly helps, but sometimes I feel like that the old saying, preaching to the choir, whatever can be done to expand that. I think it's just so important that with the Family Law Conference, that there's always a presentation with domestic violence. Anytime you've got a big gathering of lawyers, I think that focusing on that is just so important. And I think that for the younger guardian ad litems that are being trained, that sometimes there's a misnomer, oh, the child is 2, the child doesn't know what's going on. And that's just, it's the furthest thing from the truth. Trauma, we know, is something that a child carries with them their entire life. And I think that in particularly is making sure that that education occurs, because I think that there still is a statement that you hear from lawyers from time to time. Oh, the child didn't see any abuse in the house. The child didn't see one parent hit the other. And honestly, it just makes me cringe, because we know that given how the child displays himself at school, at home, and future relationships with peers, that trauma is something that they experience and carry with them. Even a child that's an infant experiences it. Child always over here or hear the fighting, they can sense the anxiety, and children, they just take that on.
How do you gather information when you're trying to recommend something to the court, whether it be for an adult survivor of domestic violence or a child?
Well, it's different. And so, with an adult, you rely on the adult to provide you, the victim to provide you as much information as possible. It can be a challenge, obviously, if someone has left an abusive situation. I mean, we all live and die by our phones, and the cell phone may not be something that they have access to. The good news is that the law is catching up with victims in terms of being able to maintain that cell phone number. The law changed several years back, but still, even if a victim can port their number, if you will, they may not have been the primary person on the account. Somebody may hack in, the abuser may hack into their account, and all that information may be gone. But certainly that's the primary source. If there's any family members, friends that have witnessed any type of the abuse, or if a victim has reached out to somebody pretty contemporaneous to the abuse, talking with them, if there's any medical records, if there's any police reports, those would be your primary sources. Or, employers as well. Employers, co-workers, if they have any information, those would be your primary sources. And for children, schools and daycares, they're always great resources. They're focusing on the child. They're not on mom's side, they're not on dad's side. They're always folks that you can rely on. Children's Mercy, if they've got any records, they're just such a wonderful partner in the community, and so user-friendly in terms of getting records from. I really find that the public schools here in our community, they also are just wonderful resources, and they're just such good partners and collaborators, and they really appreciate the outreach, and they're going to do everything that they can because they're seeing the things day to day that a child may experience, that a child may need. That's so critical. And we all can remember, thinking back, my favorite teachers in elementary school are my second and third grade teachers. And in particular at that elementary level, having children that know that they've got somebody that's a resource, that's another safe adult that they can go and talk to, and always encouraging a child that you've got somebody at school. That way you build that base for them, and as they get older and start to become more inward, as they hit puberty and middle school and going on to high school, that they always know that they have a safe adult that they can talk to. Laying that groundwork for them so early in elementary school is just critical, so they know whether it's a coach or a counselor or a homeroom teacher or some favorite teacher that they can always go talk to, because oftentimes that's where, as a guardian ad litem, I can get my best information from.
Thinking about all of the different sources of information and where you get that, how much time or conversation do you have with the children themselves?
It's always age dependent. I think it's so important that you reach out to them. The statute's changed recently, and we're supposed to talk to them in an unobstructed manner so they are free from manipulation. That's what the statute specifically says. So they have an opportunity that they can voice what their opinion is regarding the schedule. There's a couple ways that you can do that. I think that school is always nice to see a child in their environment. Schools, as long as you reach out to them ahead of time, they are cooperative about that. I also like to see a child, if it's safe and appropriate, each parent's home. I think that that helps. What I really like to do initially, especially in cases of domestic violence, it's important that if both parties feel like they can meet, the victim feels like they can meet the other parent in a safe place, like my office, I like to have both adults and the children come in, whether it's in my office or someplace that we can have a brief meet and greet. I think that that's helpful so everybody hears the same story, and that way it can't be any type of manipulation. It can't be that one parent says, oh, well, Tricia said this to me, and then they hear, oh, no, Tricia said that to me, and that there's conflicting information that really just sows the chaos and the confusion. Now, it's not always possible. Some cases it's not realistic to do that, and it's not safe. I ask both parents, and I need to assess the situation. It's more of a touch and feel than anything. You just have to kind of go with your gut to figure out if that's appropriate or not. But I think it's just so important. If I can't do it, what I like to do, if I can't meet with both parents, then what I do is I meet with each parent and the children together separately. And I say, now you remember when I met with, and I typically meet with the petitioner first, whoever that is. You remember when we met with Dad and we talked about whatever we talked about, what my role is and what I'm going to do and how I'm here to help and how what we talk about is just between you and me. Then I try to echo that, and of course age appropriate terms, with both parents, and that way we can do that. And then I may say, now you remember when I said, and one of the things I talk about is laundry. And so, you remember what the rule is about laundry, right? And they'll say, oh yeah, no, I remember, or they won't remember. That way, it validates, I've met with the other parent and the child remembers, and that way we can go back. Or I always like to talk about pets. Pets are always the great equalizer, and that's something typically 90% of the time the child likes their pets. And so we can say, well, you remember when you told me about Roger and how Roger did this silly thing over at Dad's house? You've got Fifi at Mom's house, and you remember how Fifi did this, and we were talking about how the two dogs are different, and things like that. So there's something that can validate, I've had a conversation with both, and that the children remember that. Now, obviously, I'm talking about, in this situation, school-age children, that they can remember something. But I think that that's just so important. Whatever you can do to show you were here for them, for the child, and that everybody's getting the same message. Because we know so often that anytime the legal system is involved, there's an opportunity for further abuse with the litigation.
I think that's so important because that communication so often in domestic violence situations gets manipulated and is used against the other partner. And that
Absolutely.
can be very damaging, especially if the kids feel like they're in the middle of that.
Absolutely.
That can get to be such a huge issue. So the way you describe that really would help to alleviate.
There's only so much you can do. And checking in. When I've got older kids, I text with them. They like to to text and just checking in with them. Try to make sure that I find out who is the person that's accessing the phone. Make sure that in the event that there's something that's said on the phone, that if there's a text message, that nobody's going to be in harm's way. I've had situations where I've set up Snapchat accounts so a child could talk with me separately and had safe words. Felt like that they were in harm's way at a parent's house. You just have to be creative, and sometimes the teens, and particularly, they can give you an idea of what's going to work for them. You just have to be open, and frankly, I may have to say, okay, well, that's fine. Will you just show me how to do it on my phone? And you can't be embarrassed to say that to him, to let him know, hey, that's fine. Let's do it like this, but I'm happy to talk to you in whatever format's going to work for you. Just will you show me so I know, and then let's practice.
Right.
And so that's a nice way also to show them, hey, you're human. We've got all good things that we've got to learn every day, right?
Often I need an interpreter just to figure out what my adult children are saying to me, the different generation. Speaking of parents, what are some common mistakes parents make during custody battles or disputes that can negatively impact their case?
Being on social media way too much. You do not publish your whole life on social media. That's just so important. You get off of social media. You don't volunteer information to everyone. You know that you have a few trusted folks that you can rely on. Hopefully, as your lawyer, that's something that I'm at the center of, sharing that information. If you have a need to talk, I tell folks, please reach out if you can get a therapist. If you don't already have a therapist, that's important. That's something that is often underutilized. Many times victims are afraid that therapy will be used against them, which is unfortunate. I certainly think that obviously there's a shortage of resources. You all and your services obviously offer therapy, which is a huge benefit to victims. So oftentimes people just want to tell their story and get it out. And so that may be unfortunately on social media. And that's not helpful because everybody can take a screenshot and use that against them. You may say something that is an emotional reaction, and it's better to talk about in a safe space. What I find, unfortunately, is victims oftentimes think, okay, well, I just need to make sure that the kids are okay, and I'll just get through litigation, and then I'll get to therapy after I get everything done. You've got to put yourself at the top of the list. So one of the things I tell people, and it's a good visual, I always ask them, hey, have you ever been on an airplane? If they have been, it's an easier visual form, and say, when you go on the airplane, what do they tell you? They tell you got to put the mask on yourself first. And the reason why is in the event of emergency, if you're not taking care of yourself, you can't help your children. And so you've got to prioritize yourself, and you've got to put the mask on yourself. That means go to therapy. No social media, handle therapy. Also, you don't want to be disparaging the other parent. If you're okay, the children are going to be okay. But you have to remember that as much as you've endured from the other parent, that think about that. Half of your little person, of your child, is half mom and half dad. And so when you say something negative, that really goes to their heart, because they may think, well, gosh, I look like daddy, and so are you saying that I'm bad too? To always think about those kind of things. Try to maybe put yourself in terms of how the child feels as well. So when you say things like that, sometimes the light bulb really comes on, and you can literally see with a parent, oh my gosh, I didn't think about that. The little boy, he looks so much like dad, and when I say things and I complain about dad, that hurts him as well. So keeping all those things in mind. And, obviously communication, you've got to communicate with me as your lawyer. So I know, and I tell folks, there's nothing too small that you can tell me about. When in doubt, you need to let me know what's going on.
I was listening to a podcast this morning, and they were talking about crisis communication when it came to domestic violence organizations. One of the attorneys that was talking on there had talked about, okay, so the information that I need are the facts, and what do you need right now? What's your immediate need right now? And sometimes it is so hard for a domestic violence survivor to be able to convey the facts and what I need right now, because there's so much need, especially when it comes to the court system.
Well, absolutely. And then sometimes the facts, because of the trauma that has gone on, sometimes for years, there's so much information that you get that your job as the lawyer is just to try to cull through it and figure out what's relevant, what is necessary for the court to hear, for the court to make a determination. If that means that it's a long narrative, then it may be a long narrative that we have to go through And that way, it's always nice to have that dialogue so you can learn that information from them, and to recognize too that people's needs are going to change. And with victims, those needs may change literally day to day as they uncover more, and especially if they're going through therapy, as they may have repressed memories that come out and they realize more abuse that they have suppressed. All that is just so vital.
How do you handle it when a child that you're representing, when you're wearing your GAL hat, is afraid to talk about the abuse?
Kind of my mantra is that many occasions we've had a child protection center interview. So those fine folks, they're trained forensic interviewers, and they know how to get that information. And my approach is that I handle things just organically. If a child discloses something, then I'll follow up. It's not my role, and I'm not trained to interview a child about abuse, but I ask broad-based questions about, so tell me about mom's house. And so I might ask, for example, so today's Monday. So how did you get up this morning? Did mom wake you up? Did dad wake you up? Did you set your own alarm? And just kind of walking through their day. By asking those broader questions, you can find out quite a bit about a child's life in terms of, how did you get to school? Did you eat breakfast at home? Did you eat breakfast at school? When you come home, who's home when you come home? Is no one home? Those kind of things. So I'm never going to directly ask what happened on this day. If there is another case involved, if there's a criminal case involved, because I don't want to do anything to interfere with any type of prosecution that's going on. Again, I'm not forensically trained. I'm just a lawyer.
I think it's just interesting to think about the number of people that come into contact with people who have gone through this trauma. Thinking about what level of understanding do people have if they're not actively involved in like a system or an organization where they've been trained and they learn that, and how important it is to make sure that people understand the effects of trauma. They understand the effects of domestic violence in order to really be able to help in that situation. I know that you do understand that. So when you say, I'm just an attorney, but you're an attorney who's trained and understands and is well versed on the impact domestic violence has on people, the impact it has on children. So that really does set you up to be in a better position to help the people that you're working with.
Appreciate that. I just think that in particular with children, there's so many studies out there that if you ask a child to disclose the abuse, and if a child is interviewed multiple times, not only are you re-traumatizing them, but you can essentially, my words, poison the well by asking a question that's either leading or misframes or somehow prompts an answer. And that can dilute the potential, the criminal prosecution, which is never what the goal is. The goal is you're always guided by what's in the best interest of the children. If that means that there's a criminal case that's going on, you want to make sure that you don't do anything to impact that. And there's also studies out there where if someone poses a question to a child, don't you remember that the premier study was, don't you remember that you were kidnapped from Walmart? Don't you remember you were kidnapped from Walmart? Don't you remember you were kidnapped from Walmart? And you tell the child that again and again and again, and suddenly the child believes, oh, I was indeed kidnapped from Walmart, and the child wasn't. I can remember many years ago when Judge Wimes was on the bench, and he's a federal judge. Marilyn Metzel came and testified about that. I'll never forget that. I was a much younger lawyer then. But it's those kind of things that I think you learn from both just your casework, from education, and talking with other lawyers and service providers in the community. Just always have to be open about that. There's so much out there that we've learned, that we're learning and still learning about the impact of trauma on both adults and children.
Talked about the emotion of it all, and sometimes the emotions don't match what the law is. How do you explain that difference to those that you represent, whether it's the children or a survivor that you're representing?
I mean, it's a challenge with an adult. I think it's so important. You just got to meet folks where they're at, and not everybody has the same level of education, ability to understand, and trying to assess, are they more of a visual learner, or are they more of a verbal learner? And certainly if they're, I think that whatever you can do, if it's literally handing them the statute and say, okay, in a custody case, these are the factors that the court has to look at. And here's how, in matching up, okay, here's how this fact impacts this factor that the court has to consider. And remember that the judge is guided by the law. The judge has to follow the law. Emphasizing that you can't tell a person that enough. Making sure that they understand that, especially with a child. So many of these cases, they may go on more than 2 years. You watch these children, they grow up before your eyes to try to assess, okay, where they are, what's their level of understanding, and to let them know, hey, I'm an advocate for you. You've got to let me know what's going on. To tell them, what the role of the court is, what the role of the judge is, and what my role is. And to let them know that, especially with a child, that you as their guardian ad litem are going to let the court know, I'm obligated to tell the court what your wishes are and to advocate what I think is in your best interest, and to make sure that they understand that there are other adults that they can reach out to, whether that be at school or if they've got a counselor. Always offer to help. Would it help you if I reach out to your counselor? I want to make sure it's a safe space. But would it help you if I talk with whoever the counselor is and let them know that this is going on? Or with the school, and ask, especially if it's, a middle school or a high school, you don't want to embarrass them because you want them to be willing to talk. Would it help you if I do this? And if I reach out and talk to whoever is their trusted safe person at school or therapy, or if they're involved in an extracurricular activity, make them know that that is something that's available. So you have kind of the twofold approach. One, that you're supporting them emotionally, and also letting them know that here's what my role is to support you through this litigation. If you can do that kind of parallel, that oftentimes helps them feel like, okay, I'm getting what I need, I feel supported, and then in turn that they will continue to let you know, this is what's happened, here's what's going on. So it's kind of the old success breeds success, if you will.
But it also brings up a couple of questions for me. Is one, when you're asking children to talk about the other parent or telling you what's going on, that could be getting that parent in trouble.
Absolutely.
Or that's how they feel. Mm-hmm. And kids are often just really hesitant to do that. Mm-hmm. So what's your approach when that's happening?
You hear it a lot. I mean, they'll say, I don't want to get mom in trouble. I don't want to get dad in trouble. Mm-hmm. And you have to bring them back to, remember, I don't represent mom. I don't represent dad. I'm here for you. And what my concern is your safety. And are you in a place that's safe for you? And remember that what the judge, and I will let them know, depending on how curious they are, I may show them a picture of the judge and say, okay, well, this is Judge Bush or this is Judge Fonstack, whoever it is, and say they care about you and they are focused on what is best for you. And I understand that you're worried about what's going on with mom and what's going on with dad, but ultimately what my job is to make sure that you're safe. And then I reiterate to them, do you remember what your job is? And they may say, well, remind me. Well, your job is just to be a kid. Remember, we talked about that. Mom has her lawyer. Mom's doing what she needs to do. Dad has his lawyer, and dad's doing what he needs to do. But you need to be focused on you. You can't be worried about those adult issues with mom or dad. If, depending on their age, you always have to be candid with a child if they ask. And if they say, well, I'm worried that dad's going to go to jail. If there's a criminal case, and say, I don't know, but that's something that is being looked into, and it may be possible. But what you need to focus on is you need to focus on your own safety. You certainly always have to be candid with a child, but you focus on their safety and them, and always bring it back to that.
Well, and to make sure they know it's not their fault.
Absolutely.
That even though they may be the one that's revealing what happened, it still goes back to the person's actions and their responsibility for their own actions, and not that the child isn't at fault for that.
Of course, and if you've got some recent example that you can use about, if you know that maybe something happened at school, and you can say, we remember when so-and-so got into, when they left the classroom, and how the principal held them responsible and how they had to go and sit in the principal's office. Is there's rules. And so there's rules that moms have and that dads have. If they don't abide by the rules, if they don't follow the rules, that there's consequences, just like there's consequences for you as well. Right. And to just bring it back to their terms. But Yes, whenever you can emphasize that, that's important. Even if a child doesn't express that the fact that they are concerned that they're the cause of the problem, because even if a child doesn't say that, that most of the time they still think that they are the cause of the problem.
Are there any misconceptions you'd like to clear up about the role?
Yes, I think that oftentimes I hear, you're the one that's going to make the decision. And I tell people all the time, I'm not the one that's going to make the decision. I simply make a recommendation. It's whoever the judicial officer is, they're the one that makes the decision. I simply make a recommendation, and that's it. And also emphasize that I am going to advocate for what I believe to be in the best interest of my clients. And certainly I have to advocate for the client's wishes, even if it's something, the example that I always give is if it's somebody that's 5 years old and they're getting ready to start school, and they say, oh, I don't want to start school. I want to sit around and I want to watch SpongeBob all day, or I want to stay at home, whatever the case may be. I tell parents, that may be what the child wants to do, but that's not in the child's best interest. Or if it's a teenager, I want to play Fortnite all day and I don't want to go to school and I think that I can teach myself, then that's something that I obviously have to tell the court. I think that that's really important that people understand that I always have to, as a guardian ad litem, you always have to express what the child's wishes are. That's part of the guardian ad litem standards, but that their wishes may be different than what I believe to be in their best interest, and that ultimately that by advocating for a child that I do have to take a position. That position isn't for mom or dad, that position is for the child. And that ultimately it's the judicial officer that makes the determination. I simply make a recommendation.
I'm just curious, how often do you find that the child's wishes are in conflict with what you think is in the best interest?
Not as often as you think. Occasionally you get somebody that they don't want to go to school. I don't like school, and so is a bully. But that typically passes. I'm always worried if I have, in particular, an elementary school child that isn't just over the moon about going to school. That's a real problem. So there's something that's deep-seated that's a problem if that's going on, because the overwhelming majority of children, they are excited about going to school and that they love school. A lot of times it's with the older teens, there may be some issue. I think that in my practice, I find that maybe 25 to 30% of the time you have a teen that wants to stay with a parent or reside with a parent that may not be the better outcome, better resource, better influence on them. And oftentimes it's because there aren't as many rules that are being followed. But as a general rule, I think that most children recognize that they need to have structure, and it's heartening to know that children realize, hey, I need to get up, I need to go to school, there's rules that need to be followed in school, and they want to do well and they want to succeed. But occasionally you have a situation where that doesn't happen. I don't think it's a high percentage of the time. I think a lot of people think that, oh gosh, with every teen out there, they just want to run amok and run the show and have their own rules, and I just don't find that to be the case. And I may even be high on 20 to 25 to 30%. I mean, it just doesn't happen as frequently as you would think. And, candidly, sometimes within a sibling group, you may have different siblings that they all may not be united in what their belief is. And certainly if you have that case, then, I believe that you have a duty to let the court know what you think is best for one set of children. Let's say that there's like a 10-year age span between the children, that what might be appropriate for the younger children may not be appropriate for the older children. And in such case, you may have to take the initiative and ask for a separate guardian ad litem to be appointed.
That was one of my questions. If there's siblings, do you see the whole family, or do you have separate attorneys for each child?
Depends on the circumstances, and certainly I've been involved in cases over time where we've had a large family and there have been multiple, literally each child has had their own guardian ad litem. In those cases, sadly, it's been where there's been abuse by siblings upon other siblings, and when you have that, you do have a problem advocating universally for the whole group.
Right.
And in that case, you do need to advocate. You do need to file a motion and ask the court to appoint separate guardians ad litem. And you may also have to ask for there to be a separate lawyer to be involved as well. in the event that you think that there might be, depending on the child's age, if there might be some criminal charges potentially, or if there might be some juvenile action that's taken in terms of any delinquency action that might occur as well. I've had a handful of those cases over my career, and they're tough. And I've represented both the younger children and I've represented the older children. Again, it goes back to kind of meeting them where they're at and realizing that their needs may evolve. And it's not something that's static. I think that that's probably the biggest thing in these cases, to understand the situation that a party, child, or the family has at the time of filing, that it may be different a month later, 3 months later, 6 months later at the time of trial, and realizing you have to look at what that evolution is, what their needs are.
Especially, you said earlier that, some cases could take 2 years or longer. Just thinking about the children and their progression over those 2 years, the completely different child, I'm sure, than what you started with at the beginning. Absolutely.
You always have to be aware of. It's sad and it's both heartening at the same time. It's sad when you see that a child is starting to put the pieces together and realizing this is not normal. You're impressed the fact, and you're glad the fact that they are growing and maturing, but at the same time your heart sinks when you realize, my goodness, she's understanding that all of this isn't normal. You feel terrible that the child's image of a parent is kind of becoming shattered, but at the same time it's heartening to see that a child's able to recognize, so they're able to self-protect as they get older, and that they're able to become a little bit more self-reliant and recognize, so they don't fall into that same cycle. That's something that I'm always so worried about with children, that whatever that cycle is, that it could be repeated. Whatever you can do to break that cycle.
We have a few minutes left, so I wanted to ask, have you ever been on a case that your clients have worked with Hope House and have had Hope House services, and what's the difference on the outcomes of those cases?
Oh, yes. Including currently, of course. It's phenomenal. I mean, it's transformative, both from the advocates, when I represent a victim, just being able to pair them up with the services that you have, whether it be shelter, whether it be therapy. It's just to know that there's somebody else there that's able to advocate, or if they're not directly involved in Hope House, but I'm able to utilize Hope House in terms as an expert witness to educate the court about, here's what's happened and here's why she didn't go and report to the police the umpteen different times that she suffered at the hands of her abuser. It's such a valuable resource. When I am the guardian ad litem with your many fine contract attorneys that you have, what a valuable resource. Know that they are able to get their client to show up, speak up, and follow through. It doesn't always happen, but it's so much more likely to happen with those contract attorneys. That's so important. And with that, then they can ask for the appointment of a guardian ad litem. And that way they know that the adult, the parent that is the victim, that they can have their representation focus on them and know that the child is also being protected through the services of a guardian ad litem. Again, the same thing, the therapy, the shelter that's available. And also, it's so important as a child sees that a parent is able to start taking care of themselves, then a child is able to kind of breathe a little bit and to focus on being a kid, which is ultimately what we want them to do. To say that it's a night and day difference is probably the understatement of all time.
Independence really means the world to a survivor.
Absolutely.
When a survivor finally realizes, I can do this and there's life after domestic violence.
Absolutely. Absolutely.
How often do you use the Guardian program, the supervised visitation program?
For my client base, probably the overwhelming majority of my cases, that there is domestic violence involved. It's such a wonderful resource. It's nice because of the staggered arrivals and departures, the documentation. You want a child to have that contact with a parent as long as it's safe and appropriate, and that way they can have the contact and that it can be documented what's going on in the visit by someone that is a neutral, that's not a family member, that's not somebody that can say, oh, that they're biased. You've got something that is something that can be presented to the court to aid the court in making a decision on what's going to be appropriate.
Thank you so much for coming on today. Your information that you gave us today is so valuable, and we just appreciate all you do for Hope House.
Well, thank you. It's my pleasure, and the community is so fortunate to have the resources. I remember starting off many years ago as a guardian at Lyden and seeing how Hope House has grown. The resources and the number of families that you're able to impact it's just really transformative for folks, and it gets them on the other side. It's always heartening when you get, whether it be a Christmas card or the beginning of a school year, you get a picture of a child from a parent that says, here's how he's doing, here's how she's doing, and to see and knowing that you all were a part of that and helped make that happen on a journey, that there's nothing better than that knowing that with resources folks can get on the other side and that there is life after the violence.